in the sense that laws have changed now. Those trusts are still valid. They still work. The problem is because the laws have changed, they could be more efficient than they are. And we're going to talk about what they could be doing. You're going to hear me talking about in a minute. Our concern is that these trusts, and I'm talking about as they apply after you die. And I'm talking about our traditional A and B trust. And we gave you a flow chart of the A and B trust. Do you have a copy of your flow chart right here? Let me hold this up. Right here, Ben, can you see this? This is a typical A and B flow chart. And if anybody wants this flow chart, you can email us and we will send you the flow chart. But these trusts that we're talking about is a married couple, starts out where everything is owned by husband or wife in a common pot trust. And we always assume the husband dies first and the assets are split between A and B. A represents the guy that's alive, B represents the guy that's buried, and it's really quite that simple, A and B. Now while you're both alive, there is no split. All of the assets are up here in a common pot trust. So we're talking about something that's going to happen when one of you dies. And what we're talking about is we want to amend, and we're strongly suggesting that you amend the B trust. The B trust, that's the one that becomes irrevocable when you die. So the problem is this isn't one of those things, well, we'll wait till somebody dies and we'll deal with it later. You're not going to be able to amend that if one of the spouses dies. So that's what we're going to be talking about today. Now, I also want to talk about kind of a hate email that I received about 3 weeks ago. So we send this letter out to 10,000 people, and it's caused, as you can imagine, among our clients. Now, you guys remember where we're at now. We have 3 offices here in the Valley where our attorneys report to work. The Scottsdale office is our main office, but we keep 2 attorneys in our Mesa office. In Southern, we keep 1 attorney in our Phoenix office, 44th Street. And then we have 10 satellite offices. Actually, I think we're at 13 satellite offices. A satellite office would be like Prescott, Payson, Sedona, Shoalo, Safford, Sun City, Pebble Creek, Sun Lakes, Tucson, so on and so forth. Those are offices. On Wednesday, Carlos, come rob the firm because all the attorneys are gone. On Wednesday, it's Winnebago Wednesday, and every attorney at Dana Law Firm, there's 10 of us, we all get in a car and we drive somewhere and we work for the day. And then we bring that work home. So I'm telling you this because we're operating in these cities. That's how we were able to get so many clients, 10,000 clients. Now I'm telling you that because I want you to understand this hate email that I got and how I responded to it. The hate email started out by saying, why are you sending this to all your clients and saying you don't know whether it applies or doesn't apply? Why aren't you just sending it to the people that you know that it applies? Well, the problem is, I love all of you to pieces, especially you, Carlos. We go way back. But I don't remember exactly what your estate plan says. I can say generally, this was a very prevalent practice of the Dana Law Firm to set up this A and B type trust. But I don't know specifically your plan. And so the problem is, it's really, who bears the burden? And the other thing is we don't store 10,000 files here. It would be way too expensive. So the files are they're stored off-site. So when you call up and say, what does my trust say? Then, we have to send somebody on to storage, pick up the file, review the file, call you, tell you what it says and how it applies. So we're putting the burden on you to find out whether this applies. And we're giving you some ways that you can find out for free. And in this seminar, I'm going to tell you what clauses to look for in your document And when you see those clauses, then you know it applies. Now, once you know it applies, then the question is, it's your decision whether you amend it or not amend it. It's not, when you hired the Dana Law Firm, you didn't hire us for life to do every amendment that Congress comes up with. What you did get is we promised you, and we're fulfilling that promise, that if there was a change in the law, our duty is we'll let you know what the change is. We'll let you know that we're suggesting you amend it. Then it's your duty from there whether you amend it or don't amend it. So when this hate email said, why didn't you just notify the ones that applies, it would be too big of a burden, too costly and time consuming for us to pull that many files and look at it. The second thing they accused us of is saying, you guys are just trying to churn fees. You're just trying to get $750 from all of your clients. I'm looking you in the eye, Carlos, and I'm looking the camera in the eye. That's not what we're doing. Believe me, we've got plenty of clients. We've got plenty of business. It's not our model to churn our clients. We're not trying to do that. We're trying to fulfill a responsibility to keep you informed. And as you're going to see, it's not our fault that Congress changes tax laws. It's not our fault. But we're telling you they have been changed, and we're going to tell you how they apply to you, and then you decide. So let's talk about what has changed. And in order to do that, we need to go a little back in history. And forgive me for talking history, but I think history will help you understand the problem and understand why we're recommending the change. But let me get a little drink here. Does anybody want any water or anything? Anybody need some water? Everybody good? Carlos, you know what I'm drinking? You've known me long enough. What do I drink?
Vodka.
No!
He knows you.
Ben, edit that out. No, I'm a Diet Dr. Pepper guy.
We're drinking the same bar, didn't we?
I'm going to quit picking on you because I know you're going to pick on me now that you know we're on tape. We can't edit that, Carlos. All right, so go back with me. Let's go back. 2001. Go back to 2000. Estate tax, really, the story begins in 2000. And I'll take you back there with me. We go back to a period of time when Al Gore was running against George W. Bush. Very heated election, as they all were getting. Very contentious. And it was very clear George W. ran on the platform. His platform was, I'm going to repeal the death tax. That was his platform, one of his issues. And of course, the Democrats' position is, you know, it's always about it's always about tax burden and taking tax away from the wealthy and putting a bigger burden on middle class. And you've always got this debate. And we're not going to get politically involved, who's right, who's wrong. But the debate among the two parties is really, the government recognizes they need tax. The debate is, you know, the more you put taxes, the more you interfere with small business and the economy. But then the other side says, well, it's also a question of if we eliminate the tax on the wealthy, it's going to put a greater burden on middle class. So you always have this tension. And who's right and who's wrong, that's what's up for debate. But George W. won the election, and he set out to repeal the death tax. Now here's an interesting true or false question. Ben's our intern for the summer. He's a student at ASU. He's studying finance. He graduates in May. And so he's a typical guy off the street, if you will. He doesn't really know about estate tax. He's only been with the law firm a month or two. But Ben, let me ask you that question as the public. Was the estate tax repealed, in fact? Was it repealed?
No.
Okay. Now let me throw that out to you. Does anybody disagree with Ben? Was the estate tax repealed?
Well, sent to zero.
Yes.
Well, sent to zero, essentially the same thing. The estate tax went away, repealed, whatever you want to say, went to zero. There was no estate tax
For a period of time.
for a period of time. Now, okay, good. What was the period of time the estate tax was repealed? Which year? You guys? Good. You guys are good. 2010. So if I said true or false, was the estate tax repealed for 2010, an answer would be yes. Notice I say an answer. But really the lawyer answer is it depends. And technically and officially it was not repealed. But let's go back to 2009 and 2010. Those were tumultuous years in the estate tax. You guys are getting emails from us constantly. The problem is when George W. passed the law remember in 2001 or 2002, he passed legislation that it would be repealed in 2010. That was passed early on. And we got to 2010, and it was repealed for a moment. But the problem was, does anybody remember the term sunset?
Yeah.
What was the sunset that everybody feared? The sunset was on the stroke of midnight of 2011. The law would sunset and revert back to 2001. Well, you know, there's our beautiful Congress in action. They pass a statute that says it will be repealed in the future, but 1 year later it will sunset back to 2001. It makes no sense, and I'm not a constitutional lawyer, but they tell me there has something to do with Congress passing legislation that's binding for more than a 10-year period with result to tax reduction. And so they tell me that in 2001, when they passed this legislation, they had to have the sunset. So there's the problem. It was repealed for 1 year with the sunset back to 2001. Now, going from 2001 forward, good things were happening with the estate tax. The $1 million exemption was moving upwards. You know, it went from $1 million to $1.5 million to $2 million. It was staggered. Every couple of years it was sneaking up. Does anybody know what it got up to before repeal happened? In 2009, just before the repeal happened, what did the exemption make it up to? $3.5 million, good. It went up to $3.5 million. In 2009, it was at $3.5 million. 2010 comes. It's repealed. Who was a famous person we all know died in 2010 and avoided estate taxes? And there were several. George Steinbrenner. $7 billion estate. State taxes would have been $3.5 billion with a B. They paid zero state tax. Now what people don't remember, and they never really understood, Congress has the estate tax tied to capital gains. They're connected. The reason they're connected is that Congress says if you die and we impose a death tax, you can't have people selling property to pay the death tax and trigger a capital gain. That would be double taxation. So Congress recognized if we're going to impose a death tax, we better walk away from capital gains. And the way they did that is say, when you die and we impose a death tax, you get a step up in basis in all the assets. The family can sell, Carlos, all of your stocks the day after you die, and there is no capital gain. That's what we call a step up in basis. Remember? Now, what I'm getting at is when they repealed the estate tax, they also repealed step up in basis, and people don't realize that. People were dancing in the streets saying, oh, don't we have a nice Congress, there is no death tax. But the problem was it kind of comes back to what the Democrats were fearful of. The estate tax was only applying to estates over $3.5 million. There'd be no estate tax. But capital gain and step up in basis applies to everybody. So in 2010, when Steinbrenner died, it's true he did not pay an estate tax. But it's also true that his family did not get a step up in basis. Which means if the family sold the Yankees or sold capital assets, they will pay capital gain. You see what I'm saying? Congress didn't just eliminate the estate tax without getting a pound of our flesh. And the pound was they're going to take capital gains on a broader perspective. Now you've got to understand why these taxes are connected, because in a minute, when I talk about the B trust, you're going to understand, now that the estate tax has essentially gone away for everybody, you still have a situation where you're not going to get a step up in basis. And what I'm going to talk to you about is a way that we can eliminate the estate tax and still get a step up in basis. But I'm giving you the punchline. The punchline is on a B trust that was designed to save estate taxes, you don't get a step up in basis. And so you're giving up something on capital gain. And then I'm going to show you in a minute how we can get both. If I need some more Dr. Pepper, doctor, not vodka. What kind of doctor were you, Carlos?
Anesthesiology and critical care medicine.
Oh, I bet you had some good stuff, huh? You could put me to sleep. I'd never wake up.
That's why you better make my trust be good.
That's right, make your trust good before you do that. Okay, so that's a little history on the estate tax. Who's ringing? Oh, okay, that's okay. If it was Carlos, I was throwing down. That would give me the excuse I'm looking for. All right, now let's go to the flow chart. Let me see your flow chart again. I'm sorry. There you go. The AB flow chart. The B trust. On your flow chart, put A on the left side, a big capital A, and B on the right side. And we're talking about the B trust on the right side. Now, this flow chart, the B trust, was created for a tax purpose. It was created for an estate tax purpose. It was created by tax attorneys achieving a tax benefit. Now, who can tell me the primary reason why a trust, when the first guy dies, splits into an A and B? A tax purpose. Why did we make people do that? Why do you have to split your trust? Can anybody dig down? Sir, up here in the front, you've been real good for me so far. Why did we do that?
To maximize the exemption of the people.
There you go. Good. What's your name?
Bob Wallen,
Bob? Good to have you. Were you a tax professional in your day, or?
CFP.
Okay, you understand. So you had some finance background, CF, certified financial planner. What Bob is telling us is absolutely correct. When a guy dies, we split this trust into A and B to maximize the estate tax exemption. In fact, it was the simplest way to get two exemptions for a married couple. Take Carlos, and I'm going to remember your name here in a minute. Josephine, right? Mm-hmm. Josie. When Carlos dies first, if Josie splits this trust into an A and B, she gets two exemptions against the estate tax. You with me? If she doesn't split the trust, there is the risk that she would only get one exemption and Carlos' exemption would be lost. That's why it was invented. I'm telling you. It was invented simply to get two exemptions. That was it. Now, once it was invented to give us two exemptions, attorneys always come along and say, well, wait a minute here. There's some non-tax benefit for this split as well. So I'm telling our people, it was invented for a tax reason, but it has two non-tax reasons that we still like. Okay? So keep that in mind. The two non-tax reasons we like I want you to write down the word casserole. Casserole. And underneath that, the second reason, I want you to write down nursing home. So the two non-tax reasons were casseroles and nursing homes. Makes sense to you, doesn't it, Ben?
Yes.
Because you've heard this seminar. Ben's heard it now the third time. Ben's sharp, but the first time you heard it, casseroles made no sense. Does casseroles make sense now?
Yes, a little bit. A
Okay.
little better.
Let me explain casseroles. When Carlos dies, look at Josie over here. Nice looking lady, Carlos. There's guys gonna start showing up on our doorstep, bringing casseroles for dinner. If they always start with casseroles, start with the belly, then they move up to the ear, start nibbling on it, then they start whispering in it, and they want Josie to change the estate plan to the new husband's kids. There will be a new husband. Josie will say no, but there will be. Actually, reverse this. Josie, I don't worry about you. You're not going to marry somebody else. Who could there be after Carlos? And you don't even like men to begin with. You just put up with him. Now, if you die first, Josie, oh my gosh, look at Carlos. You see those teeth? They're smiling. He gets 10 casseroles every night.
That's happening.
Josie only gets 2. Why does he get 10 and she only gets 2?
I know.
He's not better looking. You know why?
Oh, because men always need a woman.
There you go.
Women don't always need a man.
And play the numbers. If you're 84 in a nursing home and you're a single man, you're going to get 10 casseroles every night.
That's easy.
Carlos on Sunday night, he's looking to make a bacon sandwich. He can't even find the mayonnaise. Are you kidding me? He's yelling at his wife, where's the mayonnaise? He can't live alone, can he? So he remarries very quick. And when he remarries very quick, it starts in the stomach and it ends up on the ear. And it starts whispering in the ear, change the estate plan. Change the estate plan. What about me? What about my kids? Don't you love me? Don't you love my kids? Now, Josie is okay because you know, when she dies, her half goes to the B trust. He cannot change that. So there's the non-tax advantages. When the casseroles come, he cannot change the estate plan. Josie likes that. She likes that. There's casseroles. You understand that now, Ben?
Yes.
Number 2, nursing homes. Josie dies, Carlos alive. The biggest creditor he'll probably face in his entire life will be long-term care costs, will be nursing home costs. You with me? Biggest creditor. Actually, the biggest creditor was Josie, but they never divorced, so he never faced that creditor. Divorce is the biggest creditor you'll ever face. Second biggest creditor, nursing home costs at your age. And the third biggest creditor, car accidents. So when I talk about creditors and asset protection, I'm not talking about your Visa card. Carlos, you pay that off every month. I'm not talking about your mortgage, you don't even have one. You know, I'm talking about nursing home costs or car accidents. Now, there again, Josie likes the B trust because creditors cannot get inside. So if Josie dies and we split this trust, A and B, the B trust is protected from casseroles, cannot be changed to disinherit your kids, even if he remarries. And the B trust cannot be penetrated for lawsuits, car accidents, nursing home claims. It's possible that Carlos could even end up on Altex and on Medicaid, and the B trust would remain intact. So I'm telling you, the B trust was created and invented for a tax purpose, 2 exemptions, and then attorneys found 2 non-tax purposes, casseroles and nursing home costs. Everybody with me? Okay, once you understand that, then you're going to understand what's changed. What's changed is we don't need it for tax purposes anymore, but we still need something like it for the casseroles and the nursing homes. So at the end of the day, what I'm saying is I want to change your B trust to what tax nerds call a C trust. I want to change the B trust to a C trust. Now let's talk about that. Why is it not needed for a tax purpose anymore? Two reasons. Number one, write down the word portability. New tax law, I didn't invent it, I understand it though. Portability. Portability says if Carlos dies and doesn't have an AB trust, his exemption's no longer wasted like it was under prior law. Under portability, the law says if he dies and he doesn't use his exemption, it's portable to Josie, and she can use both exemptions when she dies. How many have heard that term portability? It's out there. I didn't make this stuff up. There's a lot written right now on portability, and there's a lot written on B trust. And there's a big discussion going around the country, are B trusts dead? And from a tax standpoint, they are dead, or at least need to be reconsidered. Because for portability, they're not needed for the estate tax anymore. And also you have, who can tell me what the estate tax exemption is now? We know it got to 3.5 million. Where did it end up? 5 million and some change now. It's 5 million indexed to inflation. That's a good thing. It's going to go up. This year it's 5,340,000 for you. 5,340,000 for you.
I wish.
For married couples now, 10.6 million. Don't even talk to me about estate taxes unless you're north of 10.6. And the statistics tell me now the estate tax applies to less than 1% of the American public. Less than 1%. It's not needed. When we invented this thing, Carlos, and we started mass producing it, the Dana law firm mass produced it. All of the law firms across the country mass produced it. There are literally millions and millions of AB trusts out there that aren't needed for a tax purpose. In fact, I'm telling you, there's a tax penalty if you keep it. Not only is it not needed, if it wasn't needed and it didn't cause any trouble, I'd say keep it. It's not hurting anything. It is hurting something. There's a penalty here. And the penalty goes back to my old friend, cost basis. Remember I told you estate tax and cost basis are connected. On a B trust, when they're both gone, there is no step up in basis on a B trust. There is a step up of basis on the A trust. We always knew that. We lived with that penalty because the estate tax was the bigger fear. The estate tax was 55% of everything over $1 million back in the day. And capital gains was only 20% above cost basis. And so we did the AB trust, we mass produced them, we knew that they had this penalty where there was no step up, but we lived with it because we needed the two exemptions and the estate tax was the bigger problem. So I didn't cause the problem. Don't send me your hate emails. I didn't create the problem. I'm telling you about the problem. The problem is it's not needed for estate taxes, but you still have the penalty.
So it's when both spouses, not when the A trust survivor dies.
Correct.
Is what you're talking about.
That's what I'm talking about. Because when the first guy dies, we get a step up on everything. When the second guy dies, we get a second step up on the A trust, but no step up on the B trust.
Okay.
Now, factor into all that, and I'll take some questions. The non-tax purposes are still there, and we still like that. We need to protect Josie from Carlos' casserole. We need to protect Josie from Carlos' nursing home. So we still have the non-tax reasons we like. So here's the grand finale. What Dana Law Firm is proposing is we amend your trust. We still keep the split. We still go half and half. But for estate tax purposes, we're going to rely on portability. And so for estate tax purposes, the original B trusts were drafted to avoid the estate tax when the wife dies. We're going to now change it where it will be taxed when the wife dies. But we have the two exemptions and we have portability. And because we're going to make it where it's subject to estate tax when the wife dies, it will get the step up in basis. So the result we're looking for, we still want the split. And I'm telling you, we're going to change the B trust to be a C trust. The C trust will still protect Josie from casseroles, and will still protect Josie from nursing homes. I still want that. But the C trust will be subject to death tax when Josie dies. So when Josie dies, we'll have death tax on A, we'll have death tax on B, but we'll have portability to give us two exemptions. Are you with me?
Yeah.
Now, the way I look at it, you've got three choices. And let's write those down. And I fulfill my duty telling you the choices. You fulfill your duty deciding what you want to do. Choice number one, you always have, is do nothing. It's not a horrible result. You still get the casserole protection, you still get the nursing home protection, but you're going to get the tax penalty by not getting a second step up on the B trust. No second step up. Now that may not be a big deal. If they both die together, it's not a big deal because you get a step up on the first death across the board. If the assets don't go up in value between the first guy's death and the second guy's death, it's not a big deal. If all of your assets are IRA that don't get a step up in any way, it's not a big deal. I remember you. Go on.
You do.
I'm trying to remember your name. What is it?
Prosky.
Prosky. Good to see you.
Yep.
So do nothing, in some cases, not a bad result. In other cases, it's disastrous. In this case, it's disastrous. Dr. Carlos dies. Assets are split. The wife's a racehorse. She lives for 20 more years. I just called you a racehorse. That's not an insult. That's a good thing. You live forever. You're going to outlive me, I guarantee it. Those assets are going up, and then she dies, no step up. That's disastrous. Okay, let me get all of these out, and then I'll take your question. So choice number one, do nothing. Choice number two is just eliminate the B trust altogether and make the trust a continuation. Carlos dies, it all goes to Josie, no split of assets. Make it a continuation, no split. That solves the tax problems. There's not going to be any tax penalty, but you lose nursing home and you lose casserole. So if you don't care about nursing home, you don't care about casserole, the easiest thing to do is we just eliminate the B. We still keep the trust, but when you die, we don't split it. It just continues for the survivor. Continuation. Choice three is what I'm doing with my own trust. I'm on the same list you're on to amend my trust. I'm changing the B trust to a C trust. Now, in tax technical terms, a C trust is still an irrevocable trust. Still gives me casserole. If I die, I'm married to a racehorse. My wife will live forever. And I would expect her to remarry. I wouldn't want her to live alone. But I go to my grave knowing she can't change my half of the estate. And I go to my grave knowing if she's in a car accident or she loses everything on the A side, creditors can't touch the B side. But I changed the tax wording in there to make it that when she subsequently dies, it's subject to estate tax. That gives me the step up I'm looking for. And I'm going to rely on portability to give me the 2 exemptions. There it is. Back to John? Bob.
So if your only trust asset is a residence as community property, is that an issue? It seems you have to still have step up on the basis of those.
You get the step up on the first death, double step up. And then if you split it between A and B and half goes in the B trust, then when the wife dies and the kids inherit, no second step up on them. So it could still be an issue, depending on the value. Now, if you don't think it's going to go up likely and not a big deal, then it's probably not a big deal.
You still get the 500,000 exemption or whatever?
Well, when one spouse dies and you do the split, you only get a 250 exemption.
But the B would get 250 or no?
No, just the A. Yes.
When both,
Oh, and let me repeat that for the camera. Ben, I saw you. You know, I told Ben to stick up a finger if I screw up, but I didn't tell him to stick up that finger. Ben, that's not the finger I told you. It's this one, right here.
Okay.
Very rude of Ben to do that. I'm going to tell your intern at ASU. No, I'll repeat the question. The question was, he said, is this thing a big deal if the sole asset is a house? Say you have $1 million house. And his point is that losing the step up on the B trust may not be a big deal because A, houses aren't going up very fast anymore, so there's not likely to be a lot of appreciation. And second of all, you have some exemptions against capital gain that apply to a residence anyway. And so my answer would be, I could think of situations where you're right, it wouldn't be a big deal, but I can think of situations where you're wrong where it could be. So that's a maybe. All right, other questions? Yes. What's your name?
Karen,
Karen what?
Fiat,
Are you married to this
I
guy?
am.
Did I do your work? Or did Todd Smith?
Trevor did.
Trevor Whitey, Mr. Whitey. How'd you like Trevor?
He's great.
Trevor's great. You want some casseroles? Hey, they're coming. If you outlive, you get casseroles. Go ahead.
Okay, when we both die, and it goes to our children, is there any step up for them? Or are they gonna, what kind of tax implications are they?
Yeah, that's a good question. And that's what we're talking about. If you do my suggestion, when your husband dies first, you get a step up on everything. And if you do my suggestion, when you die 20 years later, you get a full step up on everything. That means the kids pay no capital gain and they pay no estate tax. This is about the kids, because between the two of you, it's not an issue. What we are talking about is as it goes down to the kids. So under my suggestion, no estate tax, no capital gains across the board. Without my suggestion, you still have no estate tax. Estate tax is pretty much dead. And they're going to have some capital gain, perhaps, on what's coming out of the B trust.
Now, if they sell assets, such as a home, what kind of tax implications?
Well, that's what we're saying. On the way you do it our way, they can sell everything and pay no capital gain. If you don't do what we're saying, you sell everything, they could end up paying some capital gains on the B trust. Yes, over here.
So there's no more B trust if you do the amendment?
It depends on which amendment you do. I'm giving you two choices. One, you can amend it just to eliminate the B trust altogether. That's what I'm calling a continuation, where it's just one trust that continues for the survivor. But I'm not recommending that you do that, but you could. I'm recommending that you amend the B trust and turn it to a C trust. So your flow chart stays the same.
But, so under that scenario, you still only have two trusts, and you're just renaming the B to a C?
Correct.
Okay.
Yeah. I'm renaming it and I'm putting in some provisions that cause this result I'm looking for to make it subject to the death tax that I'm not afraid of anymore. And when I make it subject to the death tax, then that gives me the step up. See, people say, I had a guy in one seminar say, well, what's the code section that says convert B to a C? There's no code section, it's just tax nerds. We understand the B trust was invented to keep it out of the estate tax system. Now what we're doing is changing that philosophy, and we know what we can tweak to make it subject to the estate tax, and that gives us the step up in basis.
And I'm on the nursing home side. If your trust says that you can use principal for your health and welfare, how can the nursing homes not? I understand the car accident,
Yeah.
but how does the nursing home not, isn't able to get to that money?
Yeah, Ben's telling me to, what does this mean, Ben?
Repeat the, so make sure that camera can hear what her
Well, I thought you
question
were
was.
flipping a booger off. But
No.
So her question is she understands how a B trust protects against casseroles, but you don't understand how.
And car accidents.
Yeah, you don't understand how it protects against nursing home. And you are smart to think about that because it's a little bit more difficult, but what happens on the B trust is if you make that clause where it doesn't have to make any distributions mandatory, that income is at the discretion of the trustee, principal is at the discretion of the trustee, and you have an independent trustee that's not you, then it's protected.
Oh.
You understand what I'm saying?
Yeah, but it has to have an independent trustee.
Correct. But all we do, if that situation applies, you're the trustee, is just have you resign and the next guy step in line. So we still name you as the trustee, and then we name somebody behind you, and if we want the nursing home protection, then you step down as trustee and the independent comes through. Good questions. All right, Prosky, you're a smart guy back there.
Uh-oh.
Come on, what do you got?
I don't have.
You gotta have an IRA question.
I get them.
IRAs do not get a step up in basis, so it doesn't matter. What is over here?
Could you go over portability again?
Portability, what's your question over here?
My question, what, enumerate some of the assets that are subject to step up basis.
Good question.
Or not.
Okay, question over here, what's portability again? Portability is the concept that says if you die first and you have this $5 million exemption, under old law, the only way you could protect and use that exemption was to put it in a B trust and protect it and isolate it from your wife's assets. So this whole concept of splitting the trust was designed to give two exemptions and make sure your exemption's not wasted. Under old law, you die and leave all your assets to your wife, your exemption was lost and wasted and never to be recovered. So when wife died, she only got her exemption, but yours was lost. Portability now comes along and says, you don't need to see a tax attorney to get that result. If you die and we don't put your assets in a B trust, it's not lost and wasted. It's portable to your wife. So when she dies, the tax attorney now can claim her $5 million exemption plus your $5 million is portable to her. So we can actually claim a $10 million on her return. So you don't need to split anymore to get two exemptions. You with me on that? You see that? That's portability. It's a great concept.
So there's no exemption for the first person?
There's still an exemption, still 5.3,
Okay.
but if it's not used in a B trust, then it's portable to you and you get two exemptions.
Okay.
All right, well, let me come over here. We had a question over here. What type of assets get step up and what type of assets don't get step up? And it goes, and you guys remember I'm a CPA as well as an attorney, so I understand basis. And if you guys didn't follow, in my recent years, the last few years, I got a master's degree from NYU, doctor in taxation. So I spent 2 years studying taxes at NYU. But what we're taught in tax law, assets that have basis are what we call capital assets. And assets that don't have basis, we call those IRD assets. So write down IRD. And I'll give you the distinction. Let's talk about IRD first. because those are the assets that don't have basis. And capital asset says anything that's not IRD is capital. So if we defined IRD, then everything else is capital. IRD is essentially assets that haven't been subject to income tax while you were alive. IRAs, pensions, 401ks, some annuities. These are assets that you haven't paid income tax on, and the IRS wants income tax from somebody. And they're willing to get it later, so that's why you get no step up on an IRA. They've waited too long to get income tax from somebody, they're not going to give you step up. So an IRD is an asset that has income tax liability associated with it, like a pension, an annuity, an IRA. There is no step up on that. Another example is if you sold a piece of real estate on the installment sale and you're collecting a note over 20 or 30 years, when you die, you don't get a step up on that note. We say the tax liability's already been recognized, so we're not going to give you a step up. So the answer to this question, anything other than that is a capital asset. So I think of all your house is a capital asset. All real estate is a capital asset. All stocks, all bonds, oil leases. I mean, anything else that you can think of that's not IRD is capital. And you want that step up. So we see clients once in a while that their whole estate is an IRA in the house. And then I can see cases like your question where losing the step up may not be a big deal. So that's why now you're seeing why. Can you imagine just trying to explain this all in a letter to somebody? It's just very difficult. It's something you have to hear to kind of understand it. Question back here.
Is there any protection when it comes to a car accident, a nursing home, once both of us are gone? Say the last one goes into a nursing
Good question. The question is, what type of creditor protection can be when they're both gone to the kids? And a lot of you remember working with me and Trevor and some of our guys. We talk about creating trust for your kids inside your trust. We call those GST trusts. And we're big believers in that. So you can create the same type of protection for your kids inside of your document. Yeah, GST trust. I'm getting hungry now about casseroles. Tell me what's your favorite casserole. I bet everybody's good at one thing.
Not tuna casserole, please.
Not tuna.
He doesn't like casserole, so
Really?
very seldom make one.
I love like
Oh, I
like
do.
lasagnas.
A lasagna.
Yeah, that's kind of a casserole.
Yeah.
My kids and my wife, their masterpiece, Ben, is that my wife's always done a green bean casserole. I bet a lot of you guys make the green beans with the mushroom soup. Throw a little hamburger in there. That's my casserole. All right, any other questions? Yes. Dr.
On portability.
Carlos
that mean-
Faustino,
Yeah.
anesthesiologist.
In Trust A, you have a built-in two exemption.
That's right. That's correct. That's correct. So, let me wrap this all up, ladies and gentlemen of the jury. Carlos Faustino.
Over here, it says disclaimer 9 months. Are you referring to paying taxes on the first death 9 months later? What is that?
What Carlos is referring to in the flow chart, we have that between the A and B box, there's a line that says 9-month disclaimer. That's to say we're writing it where the option is to the spouse. If they want to pay tax on the first death, they can, or if they want to defer till the second death, they can. But that we're talking about now estates above 10.6 million. So our real wealthy clients, we put in an option that in some cases you're better off to pay some tax at the first death, some at the second. So or we can defer it all until the second.
The handout says unified credit, 3,500,000.
Yeah, well, we're too lazy to
And
change.
it
Ben,
looks like
change
this
that.
was written at 10.
Yeah, it's an old flow chart.
Oh, so it's kind of irrelevant.
Well, what we're saying is that the estate tax is now 5.3, but it's all
Right.
still relevant for casseroles and all these other things. But we're changing, the amount is not 3.5, it's 5.3. The concepts are the same.
Okay.
Just for a second, how do you get your protection from nursing home costs? You incur legitimate bills, major bills at the nursing home. How can you avoid paying those?
The questions again about nursing home costs, how can you avoid paying those? And it's the fastest growing practice area at the Dana Law Firm right now is our elder law division. And you hear this concept of elder law. And it's different than estate planning. I'm an estate planning guy, but we have elder law guys. Elder law guys have a bundle of tricks on how people end up in a nursing home that you position assets in different kinds of trust where they're not counted, they're exempt, and nursing homes can't consider it, and then they qualify for ALTAX, Arizona's long-term care cost containment system. So it's a way that we, if you have parents out there that are on the verge of nursing home, they're going in and we know they're going to chew up $8,000 a month or $10,000 a month. It's a way that we go in to try to position their assets where they're preserved for the family, but they qualify for ALTAX. Go to our website and look at our elder law attorneys and you can see some of these concepts. All right, closing argument. Here we go. Ready? One more question.
So,
And I'm going to plead my case.
you were going to do two things. You're going to show us language in the trust document.
Oh yeah, let's do that. Did you bring your trust?
I did. And then the second is that there is a provision for the survivor to disclaim creating the.
Some trusts have the disclaimer and some don't.
Okay, ours does for
Yeah,
a reason.
yeah.
And if you disclaim, then effectively you're eliminating the B trust and.
If you don't disclaim, you're eliminating the B trust. Everything goes to A and then you disclaim into B.
Okay, so if everything goes to A, you still have the $10 million exemption.
Yeah,
You don't have the casserole. And you don't have
correct.
Mexico.
Essentially, you make it a continuation trust. Yeah. All right, let me do that for the camera and then we'll, his question was, and there's a couple of questions that come up like this, so I need to address it. When you talk about this A and B split that we did for, I've been practicing law for 30 years, we split these assets. There was two different formulas that we used to split. One formula, we called it a mandatory split. Carlos dies, Josephine will split this trust into two. That's mandatory. She will split. The second way we were doing it, as John mentioned up here, is we called it a discretionary split. And this is kind of your question about the disclaimer and stuff, where we said, husband dies, wife has a 9-month option to decide to split. That's a discretionary split. Now, what John is saying is if you have the discretionary split and John dies and his wife does not choose to split the assets, then that's essentially a continuation trust. You wouldn't need to amend your trust to be a continuation. Essentially, that's what it is. Meaning, you get all the tax benefits I've discussed, but you lose nursing home and you lose casserole. Now, let me give you some language to look at. The key language in all of this is Article 3. And I believe, take a look at your trust, I think it's on page 5. Is it? 4. Okay?
Page 4.
Page 4 or 5. One of those. But the key is it's Article 3. Now let me look at your Article 3 here. This is an example of a discretionary AB where he dies, wife has a 9-month option to decide. And the key language here in Article 3, look at the heading, upon death of a trustor. Look at the next line. Discretionary division of trust. See that? That means he has one of these discretionary APs. Now, does someone else have their trust? Do you have your trust back here? Do you have your trust here?
Yeah.
It's not one of ours, but
It's
who
not
has one of
one.
ours? Faustino, let me see yours.
It's an old one.
Oh, the trust.
Faustino, I'm surprised you're still alive, but.
Hey, don't push it.
But you're one of these guys that'll live to be you're a racehorse. Okay, now Faustino's Article 3, here it's on page 5. Upon death of a trustor, allocation of survivor's trust, and if you flip the page, allocation of decedent's trust. That's a mandatory split. So that's a mandatory. So both clients need this amendment I'm talking about. And then what we do is amend, then the next thing you take a look at Article 5 in your trust. That'll be the decedent's trust. That's the B trust, and that's what needs to be amended. So if you choose to do this amendment, we're amending two provisions. We're amending Article 3, and we're amending Article 5.
If it's not your trust, can you tell me what those topics are for 3?
Yeah, Article 3 would be the topic of upon the death of a trustor. It'll talk about a division. And if you see anything in there talking about a survivor's trust and a decedent's trust, that's the division.
Okay.
And then the second thing that needs to be amended is the article that addresses the decedent's trust.
Okay.
In ours, it's Article 5. All right, any other questions? That sandwich is getting to me. Is that a sandwich or a cookie?
Natural very coffee, it's right there.
It's good. I'm going to raid that tray. What other questions?
Yeah, my Article 3, which you authored, says that if the trustee does not want to create the decedent's trust, then all assets of the trust shall remain in trust, shall be administered as distributed as the survivor's trust.
That's a discretionary.
Yeah.
That's back to what he's got. Now to make it clear for you guys that have discretionaries, you still have the same two choices. If you choose to keep it a continuation trust where you don't want casserole and nursing home, you guys can leave yours as is, and then the surviving spouse just doesn't disclaim. And that would be a continuation. But if you choose to have the casseroles and the nursing home, then you need to do the amendment we're talking about, which is you make it a mandatory split, and we make B subject to estate taxes to give a step up in basis. All right, Ben, I'm going to have you go ahead and turn that off because we're going to get too long and we're starting to get into some individual questions, and I don't want people to get sidetracked. If you have any more questions, Ben, on that, they can email one of us or call us.